volume documents, volume 4, PDF 303.
Volume 4?
Yes, PDF 303, Madhas. This is in the white paper, Madhas.
303?
303. Well, this has taken 20 minutes. Yesterday, half an hour. The Lordships had given us from Monday, Malas, onwards, morning, Malas. How do we finish?
This is the white paper. That is
white paper. Now, Malas, kindly see appendix, statement showing area and population of states which have merged with the provinces.
I'm sorry, which page are you referring?
Page 303, PDF 303.
PDF 303 in volume number 3.
In volume number 4, document volume 4. It's very important, Malas. So this is, as I told your Lordships, all the states who joined the provinces. And then they were merged, provinces which merged. So they first joined the provinces and the provinces merged. And you have 21 such mergers. And the dates of the agreements are on the left side. 1148, 1148, 1248. This is after Malas, January 20, before January 26, 1950. This is important. This didn't happen with as far as J&K is concerned. Now, this is now one part. Now, kindly come to the next table. That is statement showing area and population of states constituting central administered areas, which were the chief commissioners' provinces. Now, you see here, there's no question of any merger. No question of any merger. It was directly administered. But through merger agreements.
Now these, just for a factual clarification, these centrally administered areas, what was their status under the Government of India Act? Were they were treated as chief commissioners' provinces, and they become centrally administered areas.
Yeah, correct. Now come to the third. These were princely states, Malas, which actually went to the unions. These are princely states, Malas, many of them. Kindly see, Malas. Manipur, Tripura, Bilaspur, Kutch, Haroch, Chamba, Mandi. These are all Raja of Mandi. These are all princely states that merged into the chief commissioners' provinces, which are termed as chief commissioners, directly administered.
Then the third statement is those which constituted unions.
That's right. Now
so they formed a union of more than one of the.
Correct. Now this is important, Malas. Kindly see how the merger agreements here, only 5. Now you'll see, Malas, item 1, 22 units, as I told your Lordships yesterday, in Saurashtra. Then, Malas, Jodhpur, Jaipur. This was called originally Rajputana, which included all these. Then you have 15648, Madhya Bharat. The Lordship sees that? Madhya Bharat. Then 2848, Patiala, East Punjab, Union, Travan, and then Travancore, Cochin. This is 552. Total 275, grand total 552. So you have therefore the chief commissioners' provinces. You had the province, princes merging into the provinces, and you had these 5 states. All through merger agreements. No exception, except Jammu Kashmir. Because that was not conceived in terms of 370 itself. Now kindly come to 373, Malats. This is also important. PDF 373. 3. Now what in these 5 provinces called the Union of States, what were the kind of notifications issued, Malats? What were the kind of proclamations issued? Your lordships will find at 373 onwards.
So this 552 was an addition of 216 plus 61 plus 275.
Correct.
Yes.
Correct, Malats. So now if your lordship comes to PDF 373. Now, you see that Raj Pramukh of Union of Patiala, East Punjab states, Saurashtra, Travancore, Rajasthan, Madhya Bharat, rulers of Hyderabad, Mysore, Jammu Kashmir are published. This is the proclamation. What does the proclamation say? Last paragraph, I now hereby declare. Your lordship has that? My lords have that? It says, I hereby declare that the Constitution of India shortly to be adopted by the Constituent Assembly shall be the Constitution for Patiala, East Punjab, as well as other parts of India, and shall be enforced as such. Come to the next one, Malats. Each of them, Malats, had the same proclamation. Each of them. And all that happened prior to 1950. Except Jammu and Kashmir. And you'll find that at 379, Malats.
Sibbal.
And see if you...
Mr. Sibbal, do you think it would have been a unilateral action or it was?
Sorry, I can't hear you.
It was an action on its own, or it was something which was the government of India at that time ensured that it happened. Obviously, the government of India ensured that it happened.
There was no question on its own, Malats. It would never happen like that. Some of them couldn't exist independently.
So we have understood your argument on that. Can we move on?
Now, Malats, look at PDF 379, because all those proclamations are different from the proclamation Kwe Jammu Kashmir, which is Malats 25th November 1950, before Malats the 26th January 1949.
The proclamations is the firman of the Nizam as well. The Nizam you find at page 377,
Yeah, but the
23rd of November
but the language is
1949.
different.
This was certainly not voluntary.
Of course not. Of course not, Malats. I agree. This is what I responded to my lord. But Malats, the language is different from Jammu and Kashmir.
So keeping you probably in J&K, keeping at that time the political environment, it was something different.
That's all that I'm saying, Malats.
That's
my
argument. We have understood that argument.
Yes, and therefore it was incorporated in these terms in the Constitution, which was not done by anybody else, which only shows to you that merger was never contemplated except in terms of 370. All the others became Malats through these proclamations, part of these states, and then became part of B states. All these states became part of B states. Jammu Kashmir Malats were not. It was the only state excluded from Part B states.
But equally, the proclamation which Yuvraj executed, which you find at page 379,
Yes.
which we have seen earlier,
Yeah.
says that the entire relationship between Jammu and Kashmir and the Union of India will now be governed by the Constitution of India.
Correct.
And all previous understandings
Are gone.
Are all superseded.
Absolutely. And see what the language is. The Constitution of India shortly to be adopted shall be insofar as it applicable to the state of Jammu and Kashmir, govern the constitutional relationship. So you go back to that. That is 1 and 370 only, Malats. Nothing more than that. I just wanted to show your lordships, Malats, because your lordships put me this question. I think it was a very significant query. And they all followed a uniform pattern of integration, other than Jammu Kashmir. And the white paper also says that the integration of states did not follow a uniform pattern in all cases. You will find that, at page PDF 46.
Because you have to deal with them differently.
Naturally.
I've understood that argument. Today, the issue is not this. Today, the issue is whether 370 was really a temporary thing and whether in terms of 370 it could have.
I'm giving the historical background to show the difference and why he did not merge, because in the meantime, many things had happened, including the matter going to the UN. This all happened prior to this, Therefore, the question of merger didn't arise. That's the point,
Sibbal, that has all been argued in your opening arguments.
No, I'm only giving the background to 370, I'm not arguing it. My Lord put it to me, I'm just giving the background, nothing more. I'm not arguing. I've argued 370, I'm not arguing,
Historical background also you are given in your opening argument.
No, not the merger, because my Lord put me the merger agreements. There's a difference between merger agreements in all other states at that time, that is the 552 states, and except for Jammu and Kashmir. That's all, And they have argued merger. I did not argue. Anyway, be that as it may, if just one other thing, since we are at this, your lordships put to me yesterday, and then I'll come back to the 355. Your lordships put to me that, look, there is a silence here in the Constitution. I just want to answer that. I'll read what I have to say on this, so that it's on the record. My first statement is integration was completed when the Constituent Assembly of Jammu and Kashmir completed its task, and the Constitution of Jammu and Kashmir was adopted on 26th of January 1957. The governing structure comprising the Constitution of India and the Constitution of Jammu Kashmir complement each other, and through the bridge of Article 370. The scheme operated without conflict for 70 years. This very scheme. There was never a conflict. 2, through this complementary structure, the vast majority of provisions of the Constitution of India are applicable to Jammu and Kashmir in one way or the other. This was the integration meant. Nothing further needs to be integrated. Indian constitutionalism is not bound by a single scheme of legislative relations or any homogeneous understanding of the concept of integration. 3, Article 370, sub-article 3 is not silent. What is my answer to that? It is not silent as to the consequences reflecting the relationship between Jammu and Kashmir and India after the Constitution of Jammu and Kashmir was framed and the Constituent Assembly completed its constitutional task. This is further buttressed by the fact that in 1954, by CO 48, a proviso was added to 368-2. That can't mean that the 370 was silent on the consequences. If it was silent, 368-2 proviso would never have been added. Ensure that Article 370 could not be amended, even through the exercise of constituent power, and that by virtue of CO 48, the boundaries of the state of Jammu Kashmir could also not be altered as long as 370 was in place. The Article 368 does not apply to 370 is clear from the fact that 370 starts with a non-obstante clause. So it was not silent as to the consequences. Next, there were no silences left to fill except the silence of the people of Jammu and Kashmir, who were never consulted and taken into confidence when issuing CO 272 and 273. That's the only silence that prevailed. Bilateralism is at the heart of the mechanism provided by Article 370, in terms of which laws applicable in the Union of India through the Constitution of India as applicable to Jammu and Kashmir are to be applied. It is this bilateral process which allows for a process of integration that is constitutionally envisaged in Article 370 of the Constitution, and any adjustment of the relations between Jammu and Kashmir and the Union must follow this bilateral process. And last of all, even with respect to 368 of the Constitution, the process of exercise of constituent power resulting in amendment of the Constitution is also given effect through a bilateral process. Bilateralism is at the heart of the said process because you have to consult at least half, get agreement of at least half the members of the states. That too is a bilateral process. Nothing can happen outside there can't be a unilateral act of an executive, not even parliament. Consider this, Malas, what we're talking about, a unilateral act of the president acting on the aid and advice of Council of Ministers, not parliament. So, Malas, with respect, I say there is no silence. So that was, Malas, just our submission, Malas, on that issue. And then kindly have a look quickly at the Constitution of India for a minute, Malas. Kindly, Malas, just look at this. Yes. Now, if you see, Malas, I'm not going to read the language. Just want to ask your lordships to notice three things. One, there are entire Article 370 has 2 colons. The rest are all semicolons. And the 2 columns reside where, Malas? They reside in D. There's a colon after D. And there is a colon after 3. 370 sub-article 3.
Colon after D?
D, Malas 37 1D. And colon after 370 sub-article 3. So you cannot exercise that power independent because it's integrated. The process is integrated, and it's only a process that we are talking about. We're not talking about powers here. 370 is only a process of integration. And Miller's Constitution Bench and Manohar mentions that. And we are dealing with the process adopted by the government of India consistent with this process of integration. We're not talking about anything else, Millers. There is no unilateral notification issued by the government of India, by the President on the aid and advice of the Council of Ministers that's before you. There is no unilateral declaration. And I'll assume for a moment, Millers, there is a silence. How will your lordships, Millers, integrate that silence into 272 and 273? Because 272 and 273 deals with 370 sub-article 3 as it stands. You will still have to say whether 273, 272, 273 is consistent with the unilateral notification to be issued by the President, which is not there and which is not before you. It's not possible to match the two. It's not possible for you to state constitutionally, Millers, that 370 notification or under sub-article 3 will justify the action taken, which is 272 and 273, which has nothing to do with the notification. If you uphold 272 and 273, you will have to uphold it on its own terms, not on terms other than 270 sub-article 3 and the proviso, because that's what they have adopted. Even if you were to accept that argument, it's not possible for your lordships, with the greatest respect to Millers, uphold the action under 272 and 273. And so I was, Millers, that's one thing I was saying. Now kindly see, Millers, please kindly see. And kindly see the absurdity of this. The absurdity is that when it comes to 371, B1 and 2, you have to consult, or you have to, the state has to concur. If it comes to 370, 1B, again you have to consult and or concur. When it comes to 373, you can abrogate without consultation, without concurrence. How can that interpretation ever be accepted by a constitutional court? Means that you don't need consultation, you don't need concurrence. You can unilaterally do it. For everything else, you'll need that. That's a constitutional absurdity. For individual articles, you have to concur, but for the whole abrogation, you don't have to concur. Even for a law, you have to concur, Millers. This is, I give the greatest respect, Millers, at least take the text and the context, Millers. not a pretext. Now, Millet, I just want one other thing. If you look at Article 371, notwithstanding anything in the Constitution, starts with it. Your Article 371A, notwithstanding anything in the Constitution. And then 371A, sub-article 2, notwithstanding anything in the Constitution. Then Millet's special provision with respect to state of Assam, notwithstanding anything in the Constitution. 371C, notwithstanding anything in the Constitution. The 368 will not apply to any provision of the Constitution in this chapter. Is that not against basic structure? If the argument is, at least I didn't argue the basic structure, but otherwise, that's also against basic structure. Why don't you set aside the entire chapter? Every provision other than one, which relates to Andhra Pradesh, starts with notwithstanding anything in the Constitution. Could be, it could be, could be. Now, as far as Jammu Kashmir was concerned, they had an added protection, the proviso to 368. That constitutionally means that the complete merger that we are talking about, dehors the proviso, could never be done. There could be an argument as far as other articles are concerned. You may still apply, use 368. You may argue that. To what extent it will be upheld or not is a separate issue, because in some of these articles, even treaties cannot be changed. Some of these articles have treaties, Mullah, between the government of India, which was entered into in the past, cannot be changed. So whether 368 will apply or not, we are not into this. I'm just getting you the scheme, Mullah. So Mullah, I'm done with this. Now, Mullah, I come back to try and finish as quickly as possible, because a lot of eminent counsel are waiting for me to finish, which I wouldn't wish to do, Mullah. I want to. Now, Mullah, just one other thing before I move on. Show me the. No. Give me the. Looks at my note, Mullah. Your Lordships don't mind, which is now rejoinder. Yes.
What page is it?
Mullah, that is rejoinder. I don't know.
What page of the rejoinder? Rejoinder we have.
Page, I'm just giving you a lot. Page, Mullah, kindly come to 23. Where is that interpretation? I'm sorry, Gopala Swami. Sorry, Mullah, 17. I'm sorry, I apologize.
17.
16. Starts at 16, but at 17.
Yes.
Now, Mullah, your Lordships will see the centrality of this, that he is part of the drafting committee. He is, Mullah, piloting the bill. My Lords, has it, Justice Vivekanand?
Yes.
Now, just see, Mullah.
This we have already.
No, just one last sentence, Mullah, of this. But before he issues any order of that kind, that is under 373, the recommendation of the Constituent Assembly will be a condition precedent.
Yes.
That explains the whole of the article.
That's been the.
No, that's the understanding throughout, Mullah, till 5th of August. And our interpretation is consistent with it, and their action is consistent with it, which we are now challenging. So that was one. Then, Mullah, now I come back to that argument, Mullah, that I made yesterday, that once the dissolution took place, 356 could not have been imposed as a matter of law.
That point to make.
And if 366, 56 couldn't have been imposed, all that happened by virtue of the power under 356 is all illegal and void. Because the structure of the Jammu Kashmir constitution is entirely different. My lord knows that any act of dissolution has to be done on the aid and advice of Council of Ministers. That applies not just to Jammu Kashmir, but to the rest of India. No dissolution of an assembly can take place without the aid and advice of the Council of Ministers. Therefore, Malads, constitutionally, the dissolution on the 1st of November was void. And you can't interpret the act of the governor and the powers of the governor and the responsibility of the governor different from other states in India. That as far as governor of Jammu Kashmir, he can do it, but the rest of the India, governor cannot do it because the provision is the same. So if that action is bad, 272 has to go. 273 has to go. And even if you assume that action is good, you can't exercise this power under 356. So 272, 273 will still have to go. Because the power is only the power to make law. You are the delegate of parliament, of the legislature. You can only make law. You can't change Article 3. And whereas my learned friend, the learned Solicitor General, cited several instances of 356 where Article 3 is suspended, but not with reference to the change of Article 3. That's the usual procedure that was followed. But not to change to amend Article 3. That is never the power given. And that is apparent in 357 subclause 2, Malas. Kindly see 357 now. It's in my note itself, Malas. I'll just give your lordships the page. Page 25, PDF 25. Yes. Kindly see. Para 60, Malas. My lord has, all my lords have 357 sub-article 2.
Yeah.
Majestic Gawai has it, Malas. This is 25. PDF 25, 357-2. 357-2. Any law, Malas, as applicable to Jammu Kashmir. That's very important. Any law, I'm sorry, Justice Khanna. Any law made in exercise of power of the legislature of the state by parliament or the president or other authority referred to in subclause A of clause 1, which parliament or the president or such other authority would not, but for the issue of proclamation under 356 have been competent to make, shall, to the extent of the incompetency, cease to have effect on the expiration of 1 year after the proclamation has ceased to operate. So how could 272 be issued? Any law made has to expire after 1 year under the Constitution of Jammu and Kashmir. One of the distinguished counsel on the other side didn't read this part. He read Malas 357-2, which is different, which is the Constitution of India. Any law made in exercise of power of the legislature of the state by parliament or the president or other authority referred to in subclause A of clause 1, which parliament or president or such other authority would not, but for the issue of a proclamation under 356 have been competent to make, shall after the proclamation has ceased to operate, continue in force until altered or repealed or amended by a competent legislature. So how do you, Malas, amend Article 3 of the Constitution and justify it? Either under 356 or under 357, because the legislature has the power to make law. How do you then do it? And that also temporary emergency laws, remedial laws. It was original 350.
Just read the last portion once again.
Yes.
One, it says law made. Is it talking about legislation made? Legislation in form of laws or enactments
Yes,
made?
yeah.
And read the last part.
Last part, which shall so cease
Yes,
to
read.
have effect
Yes.
as are sooner.
To have effect on expiration of period after the proclamation has ceased to operate,
That's correct.
except as respect to things done or omitted to be done before expiration of the said period.
Yes.
This part will have to be explained. Unless the provisions which are so ceased to effect are sooner repealed or reenacted with or without modification by act of appropriate legislature.
That's correct. So, Manoj, how can that appropriate legislature, when it comes into being, ever do this?
Just two things, Mr.
Yeah.
Sibbal. One, is it dealing with laws made and not with the effect of, will it apply also to Article 370? Or for that matter,
Once there is,
Article
once 356 is there, it will apply.
just, we are not, it's a matter of interpretation.
Yeah.
It's not a matter of taking sides.
I agree, Manoj. I'm not taking sides. I'm only taking my side, Manoj.
You are doing that.
Yes, that I'm entitled to take, hopefully, Manoj.
One, it says law made. Will it also apply to the power exercised by the legislature in terms of the constitution? One aspect. The second is, to the extent of incompetency,
Correct.
cease to have effect on expiration of period of 1 year.
Correct.
After the proclamation cease to
Right.
operate, except as respects of thing done or omitted to have been done before expiration of that period.
Correct.
So what it also protects is whatever has been done or omitted to be done before expiration of that period
Correct.
will be protected.
Correct, absolutely.
Will this not get covered in that part?
It won't, because this is an amendment of the Constitution. It's not a law.
Then you aren't contradicting yourself.
I'm not. It's not a law. This is not a law, Malad. This is an amendment to the Constitution.
So what it talks about is laws, not
No, because you're a delegate of Parliament, of the legislature. In other words, whatever power the legislature has to make laws, you can make laws. Malad, 356 is not an omnibus position to Malad take over the legislature and do what you like.
Mr. Sibbal, when we interpret, we have to interpret the section without taking, you may say in the contextual interpretation, we have to take the whole background.
I'm sorry to say that's covered by BOMA, Malad. That's not covered. That's not. There's no cavil to it. That's covered by BOMA, and I've cited all those passages of BOMA to your lordships already.
Just one.
Let's not find any other power. That's non-existent. The temporary provision.
Second last year.
But BOMA 153(4)(c).
Lordships is when we interpret, especially because your Lordships interprets the Constitution, we only make arguments. It's for posterity. It's not for this case or
Yeah,
that
you
case.
don't have to remind us. of
Your
it.
Lordship knows that. If you give such a
No, I
power
think-
to Parliament under 356, your Lordships, anything can happen. Anything can happen. And because I said that the other day, and I'm digressing a bit, with respect to Maharashtra, I said, if Maharashtra is upheld, it will happen again. And it happened in Maharashtra itself. Because we have to protect the Constitution. We don't have to do anything more than that. Our at both sides, Malas, endeavors to protect the Constitution. And your Lordship upholds it. That's our task. And upholds it for posterity, not for a particular case.
357(2) of the Constitution of India.
Yes, I will. Which was, I'm sorry, PDF. I got it, yes. Yes, I will. Has ceased to operate, continue in force until altered or repealed or amended by the competent legislature or other authority. That's right.
What's the difference between the two?
Difference is that is 1 year.
1 year.
That's only, that's.
And protection, whatever is.
Yes, in other words, the
and
legislature can
permitted to be
undo
done.
it. The legislature, means because it's been a delegate, before Parliament is a delegate.
But in both the cases, it's law made and exercise the power of legislature.
Yes, absolutely. That if this is a law made, if your Lordships believes it's a law made, then within 356, because 356 is to restore democracy, and it's only a temporary measure. Right? And Malat, not only that, you cannot take irreversible action. That also is decided by this court. That during this time, Malat, your Lordship knows the difference between state of Rajasthan and Bomai. In state of Rajasthan, they said, in Bomai, they said, you must dissolve after the proclamation has been accepted by both houses of parliament. You can't do it before. Until there's suspension, which is what I was saying yesterday to your Lordships. Now, that's irreversible. Therefore, Bomai said you can't do it. Rajasthan said it's possible before approval. Bomai disagreed. That can only happen after approval. But here what happened? It happened before. And it happened without aid and advice. That's even worse. I could have understood if the governor has sent a report way back on 20th of June. I could have understood then. But not in this fashion. Therefore, the whole motive was political, and I've been saying that from day one. The motive was political, the process was political, but the end result was unconstitutional. And Malas, I've already pointed that out. Let's not take more time of the court. What did Malas Ambedkar ji say? He said, I cannot altogether deny that there's a possibility of these articles being employed for political purposes. So what I've said before your Lordships is no different from what Ambedkar ji said. His fears have turned out to be right. So, Malas, therefore, now Malas kindly come to now. Now come to the argument. I've done with Malas the dissolution part. I've done with 356. Your Lordships have read all the judgments, Malas. I'm not going to repeat anything. Now I come to the argument of impossibility. An argument not raised, not part of the counter affidavit, not part of any pleadings, not part of any proclamation, not part of arguments the last time also, not part of the first set of written submissions, and yet we have to deal with it. Now, let me tell your Lordship the principle. of impossibility, constitutional principle of, I'll just enunciate it. If there is a constitutional obligation to be performed, and it has to be performed, then in furtherance of that constitutional obligation, the principle of impossibility of performing another obligation comes in. Give your lordship an example. The term of the assembly is 5 years. Assembly is dissolved in 4.5 years. There is no assembly. And the judgment my learned friend cited, there is a presidential election or election of the vice president, and members of assembly have to vote. But the term of the assembly expires in 5 years' time. The constitution says you have to perform that obligation. So if the assembly is in dissolution, it's impossible for them to vote. That's the constitutional principle. Where is the obligation under 370? It has to be stated in the Constitution. You can't silently invoke it. And 376 probably 3 may, not shall. There is no obligation. That's the principle of impossibility, which has absolutely no application. How is it impossible, Malad? Why is it impossible? No, you've made it possible by acting that the way you've done. That's the way to do it, Malad. Now, whether that's constitutional or not is a different issue. But it's certainly not impossible. If you uphold it, it's not impossible. If you don't uphold it, it's only unconstitutional. Beyond that, your lordships are not asked to decide. So where is the question of impossibility? That's my answer, Malad. And the judgment that my learned friend cited, Malad, what's that judgment? In the presidential election is exactly that. Namely, the election had to take place, voting had to be done, the assembly was dissolved. So how could they have voted? The proclamation was there. So that's the constitutional principle. That's it. Anything else? No. They have already. Quickly, I'll take about 10 more minutes and I'm done. Numbers. Kindly come to 272. Where is it? Page 27, PDF, page 27. Volume? Yes, my rejoinder, PDF 27. I mean, it's just, I've already argued it, Malad, that this is all beyond Malad, the powers of the president. And in any case, he has to act on the aid and advice of the Council of Ministers. So Parliament also has nothing to do with it. And Malad, it doesn't need concurrence, doesn't need consultation. That argument I've already made. And if that can't be done, Malad, then we're left with nothing. Then 273. Huh? No. Let's 273 now. But let's also kindly note. Nothing else. Oh, one second. 36. Well, let's kindly come to my the 367 argument that was made. The interpretation part. And then they relied upon Damnu Malat. That argument has already been made. I'll not repeat it, Malat. Damnu itself says that this particular change at that point in time was not a change in the substance of 370. In the Jammu Kashmir constitution is applicable, the word governor was already there. And therefore, you couldn't have interpreted it in any other way. So that's all, Malat. It's already been argued. Now come to Malat to Article 3. PDF 33.
Yes.
So, Malat, as far as Article 3 is concerned, Malat, let's assume I've made my arguments on the proviso already, Malat, that under 356 it can't be done. But now let's assume the proviso is not there. Let's assume that, Malat, all this is valid. Let's assume. Malat, how can they make the union, a state into a union territory? Under what provision of law? Okay, under what power? Then my Lord put to them that there may be a situation of a national security situation. So therefore, temporarily, you may need to do that. But the national security situation is dealt with by Article 352 of the Constitution. 352 to 359 deals with all this. So how can you use Article 3 to do that? You can't use a power in 3, and of course, that's not their case also. It's nobody's case that this was being done because of national security. Pulwama happened, Malaj, in February 2019 during President's rule. And then they had elections in May 2019. And what is the justification of keeping, not constituting the state, Malaj, for 4.5 years? Under what constitutional basis can you say that I will keep a particular state as union territory for 4.5 years? You say you are going to have municipal elections. You're going to have local government elections. There are a number of, the tourism has increased. So what's the impediment then? What's the constitutional logic, Malaj, or basis on the basis of which you can deny the people of Kashmir a statehood, which and Malaj, India is a union of states. As your Lordship rightly said, my Lord the Chief Justice, that a union territory can get the status of a state, but not the other way around. It's never happened in the history of this country. Actually, 272, 273, all this has never happened in the history of this country. Not even during emergency. So, Malaj, just one last thing, and then I'm done. I want to show you the annexures in this, Malaj. This is my argument on 3, Malaj. Others will deal with it in some form. I want to show just one. Yes, kindly see PDF 42. Now, this is dated 17th May 1949. Well, as your Lordship will notice here, and this is all documents are provided in the annexures, that at this point in time, Iyengar, Sheikh Abdullah, and Vallabhbhai Patel and Nehru were all getting together to draft 370. And on 17th May 1949 is a letter written by Gopalaswamy Iyengar. And he tells Vallabhbhaiji, here's the draft. Jawaharlal ji has seen and approved of it. Will you kindly let Jawaharlal ji know, direct as to your approval of it? No, directly tell him as to your approval of it. He will issue the letter to Sheikh Abdullah only after receiving your approval. Vallabhbhai Patel was the architect of 370. Nothing was done without his approval. In fact, he went to Parliament. Kindly see, there's another letter, another document here. 3rd November? Yes. It's very interesting, Willis. 3rd November. No, not 3rd November. No, yes, 3rd. Yes, where is it? Yes.
But look at Sardar Patel's letter at page 47, 46.
46, yes. Correct. That's the draft, Millet, of 306A. Kindly come to 244, Millet.
Right, that's that letter.
Thank you for your letter of 15th, which I have received only this afternoon on my return from the Constitution. 1 second. I find there are some substantial changes over the original draft, particularly in regard to the applicability of fundamental rights and directive principles. You can yourself realize the anomaly of the state becoming part of India and at the same time not recognizing any of these provisions. I do not at all like any change after our party has approved of the whole arrangement in the presence of Sheikh Saab himself. Whenever the Sheikh Saab wishes to back out, he always confronts us with his duty to the people. Of course, he owes no duty to India or to the Indian government or even on his personal basis to you and the Prime Minister, who have gone all out to accommodate him. In these circumstances, any question of my approval does not arise. If you feel it is the right thing to do, you can go ahead and do it. Now see the next document, 3rd November. There was some, again, this is by Vallabhbhai Patel. There was some difficulty about the provision relating to Kashmir. Sheikh Saab went back on the agreement which he had reached with you in regard to the provisions relating to Kashmir. He insisted on certain changes of a fundamental character, which would exclude in their application to Kashmir the provisions relating to citizenship and fundamental rights and make it necessary in all these matters as well as others not covered by the accession to 3 subject to seek the concurrence of the state government, which is sought to define as the Maharaja acting on the aid and advice of Council of Ministers appointed under the proclamation on 8 March 1948. After a great deal of discussion, I could persuade the party to accept all the changes except the last one. He was the one who was interacting with the party. And he was the one who finally, Malats, persuaded the party to accept all the changes except one. And of course, Sheikh Abdullah thereafter.
Sure, there was a political compromise to ensure
That's all
enough
right.
flexibility at later points of
Absolutely.
time.
All I'm saying is,
But
everybody
there's
was
another
part of that process.
You are accepting the second part also, that there was flexibility to ensure that in future it works itself out.
That's correct. Well, all that I'm saying is, Marat, they were all collaborating. The key players were collaborating in drafting 370, and this is how they understood 372.
But that argument you have already
Yeah, I've already made. I'm not repeating it, Marat. I just wanted to read these letters. So, Marat, and then I've got this table, Marat, of Jammu Kashmir, Marat, where Jammu Kashmir is the head of most of the states in India in every parameter. But we are not concerned with that, Marat. I just put it. So that's all I have to say, Marat. I just want to say at the end that, Marat, as I said, Marat, your lordships, Marat, ultimately is the arbiter of what this constitution should look like and how it's to be interpreted. But I only want to request your lordships to think of one thing, that as I walk out in silence of this court, let the court speak on behalf of the people of India. Because this court, this government, or any government, any administration acts for the people of India. And it should not be that acts are done when a part of the people of India are silent, who have never been consulted, and whose fate will be decided by the cabinet sitting here without reference to parliament, without reference to legislature, without reference to the people. Those people are central to the Constitution of India. We should not forget that. Thank you very much for giving me this time.